Hi, I'm Nicole Hemrick, and I'm the managing attorney at Hemrick O'Malley PLLC. We recently won a case at the Court of Appeals for the Second Circuit. So today, I would like to talk to you about petitions for review at courts of appeal. A petition for review is essentially an appeal from a decision that was previously made at the Board of Immigration Appeals. The Court of Appeals is the second highest court in the country. So the highest court would be the U.S. Supreme Court, and then there are several courts of appeals that preside over various parts of the country. In New York, the Court of Appeal that is relevant is the Second Circuit. In what circumstance would you be at the Court of Appeals? For example, if an immigration judge or in certain cases, USCIS denied your case, and then you would have appealed to the Board of Immigration Appeals or filed a motion to reopen or reconsider, and the Board of Immigration Appeals still denied or dismissed your case, then you could take the case to the Court of Appeals. Now, it's very important. You must file the petition for review within 30 days of when the BIA, Board of Immigration Appeals, renders a decision on your case. If you don't, that's it. There's nothing that would extend the time for you. Another important thing, if there have been multiple adverse decisions, for example, from the Board of Immigration Appeals, you must file a petition for review for each one that you want to change the decision on. Otherwise, any prior petitions for review would only address the issues in whatever the other decision it was that you submitted a petition for review regarding. Now, the case that we recently had was about a young woman who had a green card and had spent quite a bit of time outside of the United States for a variety of reasons: school, work, family issues. And when she came back, the CBP officer, Customs and Border Patrol, put her in secondary inspection and gave her a notice to appear in the immigration court. The notice to appear is the charging document placing somebody in removal proceedings. During these proceedings, the immigration judge found, unfortunately, that she had abandoned her permanent resident status, her green card, and ordered her deported. This was through a prior attorney, and then the prior attorney also, on her behalf, filed an appeal with the Board of Immigration Appeals, which was also denied. Now, what is interesting about this whole process, and what was the angle that ultimately had us win the case at the Court of Appeals, was that the judge had improperly placed the burden of proof on our client, meaning she was made to prove that she didn't intend to abandon her status, whereas with green card holders, it is DHS's burden to prove that the person did abandon their status. And because of this important distinction, the Court of Appeals agreed with us, has reopened her case, and now it is going back to the BIA, and she's going to have a second chance. If you have similar issues, such as your status as a green card holder is in question at the immigration court or the BIA, or if you have any issue that needs to be appealed to the Court of Appeals because you've had an adverse decision from the Board of Immigration Appeals, we'd be happy to discuss your case with you. Please give us a call at 833-848-7838.